I mean, for him to listen, I mean, it's self-serving hearsay. I mean, it's,
Well, I have 6 statements.
well, there's no written statement.
Once they,
No written statement.
it's recorded, it's 2 hours long, it's thereabouts. But once they ask, I think I'm entitled to ask about the entirety of the statement. I think that's the law. It's because the court's well aware it's the doctrine of completeness. The case law is complete with it.
Judge, it's hearsay. I mean, just it's flat out hearsay for him to try to put that in.
It's,
Me too. Look, it's something different to do, isn't it? So they're trying to decide whether or not the door has been opened for the defence to cross-examine this witness on some certain testimony that he gave with regards to, I think, talking to Megan Boswell herself, if I recall, which is hearsay. I think the judge is reviewing the court transcript. Hence the delay. Jury has been deliberating for 9 hours, 43 minutes. On the verdict clock, nothing yet. Oh, message. Tanya, did you just buy tickets? You fucker? Really? When is that? 26th of Feb. That sounds fucking awesome. 10, you're far too generous, mate. You're a fucking legend. Oh, yeah. All right. While we're waiting for that. So, the other day, Tanya sent me information because one of the venues close to us has an event on, and it just so happens that it is. I wonder if I can get it up. Let me have a look and see if I can find the website, and I'll show you. There it is. Okay. So she sends me this link, and it just so happens that we're doing the bloody underbelly theme, and there is a true crime underbelly thing on the 26th of February. John Sylvester and Andrew Rule. All right. Underbelly Live, true crime. Be warned, this show is uncensored with some shivering revelations from the men that actually know what happened. All the inside word from Melbourne's underworld, up close and personal with two of the finest crime writers and authors in Australia. John Sylvester, Sly of the Underworld, journalist, crime thief, chief crime writer for The Age, best-selling author with a regular crime show on Melbourne's 3RW, and Andrew Rule, Australia's Media Hall of Fame, journalist of the year, Herald Sun crime writer. Tobacco Wars, Easy Street, Mushrooms, Greg Lynn, and all the ins and outs of Melbourne's underworld war. Get in quick, this show will sell out. It's a pre-sale ticketed event. Don't delay. And Tanya has just bought us tickets to go. because she is an absolute fucking legend. What would I do without you, sweetheart? That made my day a little bit brighter. Thank you. Majority of these shows are all ages. Have a legal parental oh, I'm glad you're coming with me because I can't be trusted. Do you need to escort anyone under the age of 18 or cripples? We ask no videos or recording on the night. Oh! The nature of these shows are designed to be an exclusive look into the players' lives, both on and off the field, and stories to be only discussed behind closed doors. Oh, come on. Updated and uncensored. We'll have to go and listen to their podcast. No refunds unless the show is cancelled. If in the unlikely event the show is to be moved date due to unforeseen circumstances, no refund requests will be accepted. If the date is to be changed, your original ticket will be valid. Oh, that's all right. They didn't have concession? I don't need the address. I know exactly where the York on Liddell is because I used to live walking distance from it. Let me zoom in and I'll show you where I used to live. Did it. A bit more. All right, where's York Road? Okay, the roundabout. So this is the York on Liddell here. And you go up York Road here. And see that road there, Hawkins? Yep. That was me. Number 20. Right behind the school, Christian Fellowship. So yeah, I was about here, I think. Yeah, just about here, I reckon. What does that say? Press control. Oh, press control and scroll. Oh, to zoom the map. Control and scroll. Control and scroll. No, won't go any further than that. I better put that in the diary. Blacko. They're still arguing on the. Oh no, sorry, the judge is still reading. These two authors. Have you? Yeah. How funny is it that all this stuff is coming out now? Like, there's 2 new underbelly murders come out in the last month, and now this. It's in the pub. It's one of the event rooms. It's right next to the bistro. I think they do. I'm not sure if it's on YouTube, but what if I go back and have a look? I know they have a podcast, but Doesn't say what the name of the podcast is. Maybe just type in Underbelly podcast or John Sylvester. I don't know.
So, under a 106 evaluation, what, I guess the question is.
Yes, here we go.
Well, that's exactly my point, Judge. There's nothing misleading about what I asked. I didn't ask anything about what Miss Boswell
Copy.
said. I didn't elicit any testimony whatsoever about a statement that she made. All I asked was whether or not she admitted.
I'll
that
drop
she
it in
was
chat.
dead. There's nothing misleading about that, and nothing about what he's going to ask as far as that. All it does is further their theory. It doesn't in any way clear up any misconception or misleading.
Why is yours
information
different
that
to
I
mine?
have presented from that.
Torres case.
I sent the URL.
2002, in the defendant's murder trial, the court erred in denying the admission of the videotape of defendant's statements. However, the error was harmless because the evidence of defendant's guilt was overwhelming and nothing on the videotape remotely implied that the defendant was innocent of the crime. So, not knowing, I don't know what's on this tape. I haven't seen it. Today, hearing about it. So that's what I'm asking.
Good. My understanding of that doctrine, it doesn't. I don't have to show that there's something misleading.
That's absolutely, it does. I mean, it's right out of the.
Can I finish? I'll listen to you. I mean, no disrespect to anyone here. I'm not trying to upset anyone. But in Torres, there was an issue about that. There are other cases besides Torres. That's the first one I pulled up. There's a State versus Brewer it's the same thing. It's an issue of fundamental fairness. They ask about the statement, then they say, I can't ask about the parts I want to ask about. And if we need to take a minute, I've asked the court for a minute so we can print a couple of those cases and make sure I want to do this right. I know you want to do it right.
You've got the cases on that.
Judge, I think there's a good explanation in the unpublished case of State versus Dylan Brewer. That could be found at 2019 Westlaw 1109917. I forwarded that to your assistant and asked her if she would print it. I have not. And I've given that citation to the state as well.
And Judge, I would go back to the part. The rule requires that a writing or recorded statement or part thereof be introduced by a party. I did not introduce any part of her statement. I asked Detective Fraley if she ultimately admitted that her child was dead. I didn't ask what she said. I didn't ask how she did, if she did it, if she admitted she did it, if she said she didn't do it.
What you asked was if she made that statement too, in which she get it. I mean, I have heard that back. If that's what you want me to do, I mean.
I would further point the court that the footnotes to the rule of completeness 106 clearly talk. Mr. Scott said it didn't, but it clearly says, rule providing that when a writing or written recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any other part or any other writing which ought in fairness to be considered contemporaneously with it, provides an adverse party a mechanism for putting portions of the writing into context if the portions would otherwise be misleading. There's nothing misleading about what I asked Agent Fraley. He's not trying to clarify anything. Unless he's in some way trying to insinuate that the child wasn't dead.
Well, we're gonna take a minute. I'm gonna look for cases.
Yes, Judge, they're having a hard time going through. If we can have a minute, I'll collect and send them back. Yeah, I just make the time to do it. Back to your staff.
Okay.
Your Honor, may I step out for a few minutes?
Yeah, we'll take. We're still on. We're still on the rails.
God, we're just starting after lunch. It's 5:30 in the morning. Read over on the 7. What the fuck? Oh, there's no sound at the court, Dale. They've turned the sound off while the judge is reading. Yeah. Yeah. No change in the Griffiths trial. 10 hours on the clock. I might actually go and search, see if there's any more on that socialite trial, because there wasn't anything a couple of hours ago. It may be now. a snippet somewhere. Oh, Miss Mandy's live. Oh. Huh. You're watching what I'm watching. There you go. Might as well watch Mandy then.
I am not in pursuit, trying to catch up.
We forgive them, Moshe.
Vehicles,
Driving through people's yards.
suspects driving on a sidewalk, white male, blue shirt, black pants. Dirt bikes continuing back, heading towards Edgewood, Cross.
98, what are you doing?
It's iconic, and lights and suspect's vehicle is continuing on.
Triggered the commenters. I got like said, hey, defense press, how you doing, Jody? Jody, do you want to come up?
Got multiple patients like down, he's still down Edgewood.
Oh,
Eaton County is back on Gavin Parkway going out towards Edgewood now.
that's true, 98. If they're old enough to serve the country. If they're old enough to. Oh, you're still streaming? Okay. I'm redirecting to you. We already told you. Is he dancing? What was he doing? Or were they trying to point him in the right direction? I've seen several people now that it went another second. Okay, they're saying go back that way. Okay.
That way?
The officer is informed by several bystanders that the suspect turned down a road
Oh,
that
so I
only
actually
has
went off. That's why. Oops. Where's my feed? Yeah, still waiting. God almighty. Can you imagine sitting in that box? Yeah, me too. Should do. Well, it's been 4.5 hours. Maybe I should just leave this on a sleep stream and go to bed. I've got 3 appointments this afternoon. Joy. Yep. You're welcome to take over town if you want. You can do it from wherever. I might, yeah. I'm getting weary. I'll leave the stream running and go and watch it in bed, I think. And then I'll cut it at the end. So, sleep timer. No. Yeah, I do. You go to bed too. All right. I'm going to leave it open. I'll leave the stream open and I'll try and log in on the bedroom. Yeah. Yeah, it's 5:45. And yeah, that's it for me. You're welcome. Oh dear. I've had one for the last couple of days too. I've had to take extra cortisone to counteract it. All right. I shall go and log in on my iPad and watch on my telly. And if I've got something to say, I will jump on and say it. All righty. Enjoy the rest of your watching. Night, darling. Night, all. I'll be back. Ron. Later, Ron. I just realised I can probably talk to you through my iPad. Idiot. My arguments always hold some weight. I think there might have been lesser included, yes, of second degree. And I think that's probably where it'll end up. The verdict clock is at the 10-hour, 15-minute mark so far. Oh, I found cherries. The reason we don't have any sound in court right now is the judge is reviewing transcript from the state's direct examination of this witness, because the defence believes they may have opened the door to certain testimony elicited from the witness, and has asked to address that in cross-examination. So the judge is reviewing the transcript to see if that is the case. Hence the delay.
All right, Mr. Scott, you handed me four,
I,
3, 4 cases.
4, I think. Be ready here. Judge, I handed you the unpublished case of State versus Brewer, and that case contains a pretty good explanation of that it does cite to several published cases. If you go to, if the version you have of Brewer has a page 12 at the bottom, does it?
Yep.
If you go down to the last paragraph of page 12, it talks about 106 is a rule of timing and admissibility, and talks about whether it's not immediately clear where it would admit the introduction of otherwise admissible hearsay. That paragraph goes on to state, though, however, it has long been the law in the state when a part of a confession or admission is entered into evidence, the defendant is entitled to have the jury consider the entire confession. That cites Curry versus State, 397 Southwest 2nd, 179 at 181. That's Tennessee Supreme Court, 1965. And Samblin v. State, 387 Southwest 2nd, 817 at page 820. And that's, again, Tennessee Supreme Court, 1965. And they go on in this case, they talk about when when a confession is admissible, the whole of what the accused said upon the subject at the time of making the confession is admissible and should be taken together. If the prosecution failed to prove the whole statement, the accused is entitled to put into evidence all that was said to him or by him at the time which bears on the subject of controversy, including exculpatory or self-serving declarations connected herewith. It is for the jury to say what weight shall be given to several parts of that statement. For they may well believe the part that which charges the prisoner and reject that which tends to exculpate him. And that's a direct quote from State versus Robinson, 622 Southwest 2nd, 62 at page 71, Tennessee Supreme Court, 1980. And in this case, in Brewer, the Court of Criminal Appeals goes on. This case is kind of almost on all fours the way I see it. The Rule 106 here in Brewer, the state examined on direct examination a witness about a statement. It did not put in a play that it put the physical statement in, nor did the officer read the statement verbatim. But they said the rule of fairness should allow you to place the whole statement in. And I think, Mr. Fraley was asked in this case, he was asked about taking a statement. I think he was asked a couple of times about taking a statement. And he was asked about her admitting that the child was dead. Well, certainly in a missing persons case, when you admit to the police that it's been shown and alleged that you're lying to, and Mr. Fraley, although the court granted an objection, said earlier that she was telling lies. And then when she fesses up and says the baby is dead, certainly the court should take that as a confession. And I think he was asked about the baby being dead, and the response was that the baby was dead, among other things. So that leaves that out there for the jury to be wondering what the other things are. That's my recollection. That's Mr. Horn's notes. Now, that's essentially my argument. I'll rely on the other cases I gave you, but I think that Brewer case gives the best explanation. Although it's an unpublished case, the cases it cites to certainly are published. And if you have any questions, I'll be glad to answer those. If not, I'll yield to Mr. Harper.
Yeah.
Judge, I would agree with Mr. Scott. I think the Brewer case is on point. I would disagree with him as to how he's reading it. However, one, I don't think anything about what I elicited was in any way a confession by Miss Boswell. And two, I would rewind a little bit from where Mr. Scott quoted on page 12 of the opinion. Because the danger that we're trying to avoid here is misleading the jury by providing only inculpatory parts or parts that somehow make the defendant put the defendant in a bad light, and not putting forth the parts that are inculpatory or in some way would mislead the jury about the proof. And in the paragraph above where Mr. Scott quoted the rule of completeness that was explained by the Supreme Court, it talks about that the rule must do one of the following, and then it lists 4 things. 1, explain already admitted proof. 2, place admitted proof in context. 3, avoid misleading the trier of fact. Or 4, ensure a fair and impartial understanding of the already admitted proof. Well, what he's trying to elicit doesn't do any of that stuff.
See, that's my problem. My problem is I don't know what he's trying to do.
Well,
I have not been told yet.
all right, I guess I'll go ahead. I believe he's trying to elicit that what Miss Boswell told Agent Fraley was that her.
Step out.
And Mr. Suck can correct me if I'm wrong, but I believe what he's trying to elicit is that Miss Boswell told Agent Fraley that Hunter Wood, the defendant's boyfriend, rolled over and killed the child. And that was what she told Agent Fraley at that time. I don't know how that corrects in any way his statement that she admitted the child was dead. I mean, if anything, that's the fact she was there is more inculpatory to elicit that than it is correcting any sort of misleading impression that might be out there as a result of what Agent Fraley's already testified to.
Are you satisfied that that's an accurate summary of what the proof is, or do I need to hear the whole 2 hours?
I would,
Because there's, in this case, I don't recall which one it is, but I read that one of the arguments was that the defendant on possibly the post-conviction case, it was argument that because the judge relied on the summary of the proof instead of reviewing the entirety of the proof, that the judge couldn't make that decision.
I think, and Mr. Harper can correct me if I'm wrong, I think I'm generally satisfied with what he's saying, but she explained how the baby died, where the baby, or maybe not where the baby went, but I think that Hunter took it in that statement. Am I right about that? She gives an explanation. And I guess what I'm trying to say right now is it's fundamentally unfair. And I think it does satisfy at least 1 or 2 of those things that Mr. Harper's talking about in the paragraph above from Brewer. Explains the already admitted proof and puts it in context. Well, right now you have a case where the jury's heard this TBI agent say, yeah, she's lied and she's basically led us on wild goose chases, but she finally admits the baby's dead without putting in the full explanation of what she told them. And I think for the jury to hear that, there's no mention of anyone else in what was put in. She tries to explain to him what happens, and I think it explains it, and it avoids misleading the trier of fact from the standpoint of the jury. You don't know what this proof is. Mr. Harper and me, Mr. Harper, Ms. Maskill, we know it, and I think you said that's where you're struggling. Well, you have.
Obviously, it's where I'm struggling because the test that the Tennessee Supreme Court has given to the trial judge is that it is an issue of fundamental fairness. it isn't an issue of one snippet of one statement misleads the jury. That's not the test. That's not the question. The question is it fundamentally unfair if I, as a trial, don't allow you to put in the entirety of the statement based on the very narrow, and I understand General Harper was being very careful and cautious in what he was asking. So what I think where we're at is that I'm going to have to, is it transcribed? Is it audio? Is it video?
It's 2 hours.
Well,
I guess we could fast forward. to
I
that.
think I've got a clip of just that portion.
Well, here's the other thing. If you want to give me just a clip, obviously it speeds it up today. But then if the jury ultimately convicts, then on post-conviction or during the appeal, the argument's going to be, oh, well, the judge didn't review the entirety of the statement. And therefore, he couldn't have made an appropriate determination. So here's where we're at. It's my opinion, and believe me, there's nobody in this courtroom who wants to keep this case moving. But it's my opinion that you're going to have to give me the audio, video, whatever it is, and I'm going to have to go back to chambers, and I'm going to have to review it. And then I can come out here and make a decision based on this law. I think that's where we're at. I don't want to send the jury away, but I'm not going to make them sit out here for 2 hours.
I think maybe you're gonna have to. I mean, if I'd have known this was gonna come up,
I know.
if they'd have known, we'd have brought this up, but
I'm not mad at anybody.
but I do think the court needs to consider when you do this, is this a confession? Because those state Supreme Court cases that are cited in Brewer go back to 1965, and I don't think.
Well, I'm going to tell you what I'm going to do. And the last case that you gave me gives me this freedom. I'm not going to go back to 1965. I'm going to rely on the rules of evidence as they've been enacted in this state now for some time, in the cases that talk about the rules of evidence. 1965 predates our rules of evidence.
I understand that.
And even our Supreme Court in one of these cases says, look, the defendant in that case made arguments relying on the old cases. And the Supreme Court says, look, we're going to look at this under what the rules of evidence say, and that's where that's my story.
I want you to understand my position is this. I think the defendant under due process protections given to her by both the Tennessee Constitution, the federal Constitution, has a right to fundamental fairness. And I think those cases, that's what they're talking about, is fundamental fairness. So
Okay, just sit there.
I'm not sure that there's a difference if there's the rules of evidence provide for fundamental fairness. I understand what you're saying. Just make that decision. And if I'm wrong, I think we're on the same page at least. Is what needs to be done.
I'll find it. I'll comment about it when I get
Yes, sir.
where we're at right now. I'm going to have to bring the jury in. I'm going to send them, since this is day one and they've not been to the hotel yet, I'm going to go ahead and just send them to the hotel. So I'm going to have to, is it listen to or watch?
It's video.
It's video.
All right. We may have the whole issue about whether I can see and hear what's being said. I've had another case where I had Sullivan County videos that I could not hear.
These are pretty clear, Judge. There used to be there shouldn't be any problems.
So I need to bring a jury. Lieutenant, so you know, I'm gonna go ahead and send them to the hotel.
Yes, sir.
Let them get settled in.
Yes, sir.
We'll start back. I need to go in.
Your Honor, I think if you, did we not get the, in that other case,
I
those
got- I
statements
still
with the
got this.
Bluetooth,
I still got this.
did it work that way?
One stand, please. You may be seated. Thank you.
All right, ladies and gentlemen, I hope you enjoyed lunch first. Second, we've got a legal issue that's come up, and I have to do a little bit of research so I can come to the right conclusion. And it's going to slow us down a little bit. But since this is the first day of sequestration, I'm going to go ahead and have the officers take you to the hotel so you can get settled in. Your luggage should already be there. I think they've already told you all that. Then they'll take you out to dinner tonight to some undisclosed restaurant somewhere in the Tri-Cities. But before you go, I'm required by law to give you certain admonitions. One, you're not to communicate with other jurors or anyone else regarding any subject connected with this trial. You're not to form or express any opinion about the case until it is finally submitted to the jury. You're to report promptly to this court any incident involving an attempt by any person to improperly influence any member of the jury. You're also to report promptly to the court a juror's violation of any of these admonitions. You're not to read, watch, or listen to any news reports concerning this case. You're to decide this case solely on the evidence introduced in this trial. Okay? Now, we'll start back at 9 o'clock in the morning, and I will see you then.
One stand, please. You may be seated. Thank you.
So, y'all, we'll be in recess till
Yeah.
8:30 in the morning. I need y'all to get that statement to me changed.
Send it to me, will you? I'll get out something.